Okay.
Well, did he find anything that was loose?
Oh, we're good to go. You ready, Heidi?
Yes, I am, Amy.
Okay. Well, wait a minute. It says my screen sharing has been paused. Give me 1 second. I've never seen that before. So let me stop sharing and share again. Is it up?
Yes, now.
Okay, good. Okay, hi everybody. My name is Amy McGarry and I am here with Heidi Brown today. We're both board certified elder law attorneys practicing here in Lee County. This is for the elder law section of the Lee County Bar. We've been kind of on a pause for a while, but we're going to start bringing back some CLEs so that everybody can start learning what's going on in the elder law world. So let's delve into this today. And so we're going to talk about, I'm sure you're all aware when you signed up, that we're going to talk about the superpowers and why are they important for elder law attorneys, and looking at it from an elder law perspective instead of the straight estate planning perspective on this. So we're going to get moving. I don't know why. Did it come up? There it goes.
There it goes.
I apologize. There we go. Okay. Sorry, little technical difficulties. As you can tell, I wrote the slides. My daughter decorated the slides, so bear with me. Okay, so we're going to talk first about where you find the superpowers. The superpowers are found in the Florida statutes under 709-2202, and they're actually not called superpowers in the statute, but that's what everybody has dubbed them since the law changed back in 2011. But it is the authority that requires this separate signed enumeration. What does that mean? So that means that each one of these have to be individually either initialed or signed. We have seen powers of attorney that will have that say Florida on the top, that say above all. Those clauses do not work, and your clients will have an issue if you do that. There is language in that statute of what happens if the principal cannot sign. So if the person cannot sign, they can do it by X or by the notary if they have a physical limitation to doing this. And so there is directions on, right in the statute, but we put them in here, of what the notary has to do. And the notary has to write the signature initials affixed by the notary pursuant to Florida statute 709-2202 below each one of those individual. You cannot do it again for all. So if you do have a principal who has physical limitations, it is going to take a little longer because you want to make sure all that is in there for them. Heidi, tell us a little bit about what you've seen powers of attorney coming through with people. That's why we started with this, because of what you're seeing and how it is affected when you go to do long-term care planning for people.
Right. So sometimes I will see power of attorney documents that have been prepared by either a Florida attorney, or sometimes I suspect they are coming from a website. And these power of attorney documents are drafted for Florida principals. And of course, one thing maybe we forgot to mention, but the law has changed back in, I believe it was October 2011. So if you have a really old power of attorney document that was prepared before then, that document doesn't necessarily have to have these powers either specifically initialed or separately initialed or separately signed. But after October 2011, if you want to have the agent be able to have this authority, those sections or powers do have to be separately signed. So sometimes what will happen is I'll meet with families, and sometimes by the time that the family comes in to talk to me, their loved one is already in a nursing home, or they're already in assisted living facilities, and it looks like they're going to need to be in a facility for a while. And a lot of times the person's no longer competent. And so I will ask for, is there a power of attorney? And the family will give me a copy of the power of attorney. And a lot of times what I'll see is, even though it's a power of attorney prepared and signed after 2011, this document will not have separately initialed powers. So what it may say is, for example, the power to gift. It may say, oh, well, I grant my agent the authority to gift, but it's not separately signed. And if that's the case, the agent can probably use the power of attorney document for the other actions that don't require the signature, separate signature or initials, such as banking typically doesn't, typically investing doesn't. But if they want to perhaps do some type of gifting or transferring of assets, then we will not be able to use that power of attorney. I also see it with the ability to create trusts. So a lot of times people have to apply for Medicaid to pay for, let's say, their income. And I'm sorry if I jumped ahead.
No, that's
I'm sorry,
okay. You're going right into the
much,
next slide. So
too high of
go
income.
ahead.
And so what can happen is we need to prepare a trust for them. Well, if the power of attorney agent, I'm sorry, the power of attorney document does not have that separately initialed, then the agent may not be able to set up a trust. So that's another example I see all the time. So Amy, do you want to go more into what a inter vivos trust is?
Yeah, so these are your living trust, where your what the court is looking for, or what the statute is looking for, is that the principal would be the grantor to be able to do these. And so there are these trusts that we use in long-term care and Medicaid planning. The biggest one probably, which catches us the most, is the Qualified Income Trust, or you may have heard it as the Miller Trust, which is the name of one of the parties in the Supreme Court case, that if somebody is over the income limit in the state of Florida, that they have to have their income, the overage, run through that every month, or they're not going to qualify for Medicaid. And if they don't have this, and the power of attorney is good, like Heidi said, for everything else, then we are opening up probate, or opening a guardianship up, for the sole purpose of having the court approve a guardian to be able to sign this qualified income trust. Mm-hmm. And it takes longer, the cost involved, and now you're going to be involved with the court, because even though you have least restrictive alternatives, the court did grant that approval of that trust, and some of the courts are requiring that now you have to do an accounting for this income trust every month. The accounting's not bad because the income goes in and out every month to pay the nursing home, but it's just another cost that the clients have to bear trying to get Medicaid, and it could slow down, and they could lose at least a month of eligibility, because we do not have retroactive eligibility anymore in the state of Florida. Right. Another is setting up a pool trust. So if somebody is over assets, and one of the things that we're looking at to do is to fund the pool trust to be able to protect those assets without having to worry about the 5-year look back period. Again, there is an issue because the agent isn't going to be able to do this. Now, if the person is capacitated, they can sign it, or if they have a spouse, they can sign it, or if they have a parent, they can sign it. But most of the time, we're not going to have those issues. And then this is what is leading us to be able to do that. Heidi, you want to talk about the first party and third party special needs trust and why those are important? That may pop up as well, because you may have clients with tons of money and you're thinking, well, they're never going to have Medicaid. Why do we need this initial? So if you can explain about those two.
Sure. So when you say that you have a client that has a lot of money, what a lot of people don't realize is what the cost of long-term care can be. For example, we're now seeing skilled nursing homes that are $18,000 a month. And we're seeing assisted living facilities with that are $8,000 to $10,000 a month. And so even someone who has a really good long-term care insurance policy may still find that they need to try to get on Medicaid to pay those fees, because most people just can't honestly afford, $18,000 or $10,000 a month. So that's part of the reason why this is an important topic, because you just never know who may end up needing long-term care. And I believe that there's a quote by Genworth. Now, yes, they used to sell long-term care insurance, and this was as of a couple of years ago, about 70% of Americans will need long-term care at some point in their life. So that's another reason why this is an important topic. But she had asked also about first party special needs trusts and third party special needs trusts. And these are two different types of trusts. So a first party special needs trust is one that the Medicaid recipient or applicant, or somebody who is on SSI, sets up with their own money. So let's say I'm on Medicaid and I'm under 65 and I inherit $100,000 from my dead aunt. That $100,000 may kick me off of SSI or Medicaid, but I may still need SSI or Medicaid, to pay my medical bills. So what I would do is I would have to set up a first party special needs trust, because I've already received the money from my aunt's estate. And with this first party special needs trust, it is use it or lose it, so that when I die, if there's any money in there, it will have to go back to the state of Florida to repay a Medicaid lien. If I was in other states, it may have to go back to their state to repay the Medicaid lien. Now contrast that with a third party special needs trust. A third party special needs trust is one that is set up not by the Medicaid recipient or their spouse, but rather somebody else. It could be a parent, it could be a grandparent, and it's with the parent's own money. So let's change my example to say that my aunt, before she died, did some pre-planning. She knew she wanted to give me $100 grand, but she knew I was on Medicaid. So she went to go see Amy, and Amy said, well, you need to prepare and sign a third-party special needs trust for Heidi, so that Heidi never gets that money outright. Instead, the money will go to this third-party special needs trust, and the trustee will be able to pay for things for Heidi. But when Heidi dies, if there's any money in there, it can then go back to whomever you want it to go to. It could go to your beneficiaries, your kids, your charities, wherever you want it to go. There's no state payback with that third-party special needs trust. And so basically, that's the difference between those two types of trusts.
Well, and Heidi, looking at it is, let's use your example where the client would come to me to do the preparation. Well, let's say that they had where the account was just going to you, and you were healthy at that time. And then aunt became incapacitated. And now then you ended up having some sort of disability and put you on SSI or on Medicaid. And aunt can't update her trust or even do a trust. At this point, this is why this is important, so that aunt's estate plan can still be done and forwarded. And that leads us also into trust amendments, so that we can amend that trust if there is already a trust in there, to be able to add that third-party special needs trust in there for the person who in the future became incapacitated. So these are important, where you don't have to not only think just about your client, but it may also be the beneficiaries of your client that may need the long-term care or the Medicaid, that we have to then make sure that we think about, that we put it in there, because the difference between those first party and third party special needs trust is huge when it comes to Medicaid recovery. So trust amendment is going to be the next one, which Heidi is just basically, they kind of go hand in hand, but under the statute they are two separate things. The next one is huge that people do not like to initial, and that is gifting. The statute, when it says it is gifting, if you are silent, even if your client signs a gifting paragraph, if the power of attorney does not specifically says that it can exceed the federal gift tax exclusion in a separate initial power. I know this is adding more boxes to initial, but that's the way it is stated. Then the gift is going to be limited to the $15,000 annual exclusion. And again, we don't know what Congress is going to be doing with these annual exclusions coming up in the future. They may be lowering the gift tax. So these are things that we have to think about now, that your client may be going, well, I'm not going to be gifting, but it's more than just gifting to their children. They may need to be gifting for tax purposes coming up in the future, especially if the estate tax gets lowered like everybody thinks it's going to. The other thing is they may also have to do gifting for long-term care planning, which is where we see it. Heidi, can you talk about a couple examples of why having that gifting paragraph and the separate one to do the full exclusion is so important?
Yes. So let's say, for example, a wife comes into my office and says, my husband needs to get on Medicaid right now. One of the strategies that we can do is to transfer all or most of the assets from the husband to the wife. So we're going from the sick spouse to the well spouse. Now, if the assets are already jointly titled, that is makes it easy. But let's say that the husband had assets that were only in his name. In order for us to transfer them, whether it's with the bank or signing a deed, there will need to be a gifting provision separately signed in the power of attorney. And because I'm imagining a lot of these transfers will be more than $15,000, we will need that separate statement to say that it can exceed the annual federal gift tax exclusion. Or else all we'll be able to do is transfer $15,000 to the quote well spouse, which may not be able to get us where we want in terms of planning for or doing crisis planning for Medicaid purposes. Another time we use gifting, and we also can use and the power to create a trust, is sometimes we'll do that for VA purposes, for pension with aid and attendance has a look back of 3 years. And sometimes we know 3 years ahead of time that somebody is either a veteran or a widow of a veteran and may need VA at some point. If that person is no longer capable of signing an irrevocable trust, then it would have to be done by power of attorney, and both the gifting section, the gifting power to gift more than the annual federal gift tax exclusion, and the power to create a trust, all of them would need to be initialed.
Yeah. And, this comes up, we see it where the nursing home spouse, Medicaid spouse has a life insurance policy that has cash value to it. Well, that cash value is going to exceed, and that a nursing home spouse is only allowed to have $2,000, where we have some room under the community spouses resource allowance to be able to move it to that spouse, to the community spouse. Well, again, that's wholly owned by the nursing home spouse. The insurance companies need to see that those paragraphs are initial, being that this law has been into effect now it's coming up on 10 years. The insurance companies are very aware of what Florida's policy, or what Florida's statutes say. The other is not only between spouses, but you can also gift when it comes to preparing the enhanced life estate deeds. You may have heard them as called ladybird deeds.
Yeah.
That's also going to come up, where it's not just one of these initial paragraphs. There are several, and how Heidi was just talking, how they interact with each other. But also, and I forgot to put it on the slides, but if one of the children is disabled by Social Security, we can actually move the money to the disabled child without any 5-year look back period. So we also have that. Now, you got to be very careful to see what benefits the disabled child is on, but that is another way that we can do it, that it's not only going to be to the spouse, but even the enhanced life estate deeds are going to be going to most likely the children. And so we're gifting that remainder interest to them. And if anybody's wondering what EPIC is a program in the state of Florida, Elder Planning Income Concepts, that we are blessed to have here in Florida, that if people need to purchase rental property, and it usually starts about $20,000 minimum, that they actually buy an interest in real property, and it is done by attorneys up in the Ocala area. So if you're just getting into elder law and you need, don't hesitate to reach out to Heidi and I, and we'll put you in connection with those attorneys up there, because rental property is allowed in the state of Florida as an exempt asset. The income isn't exempt, but the asset is. So let's talk about creating or changing rights of survivorships. Again, this kind of goes in hand with gifting for the remainderment on those life estate deeds, but it can also be adding tenancy by the entireties to real estate or to intangible personal property to add protection for your clients that may not have anything to do with Medicaid. We're just trying to do asset protection for them. And one of those spouses may be incapacitated and somebody needs to do that. Or how many times have you gone where you're working with clients and somebody may be incapacitated, and now you see a bunch of assets that were never titled in trust, that didn't have any beneficiaries on it, and now triggering a huge probate because all those assets, they have all these documents, estate planning documents done, but the assets are running wild of what's going to happen when somebody passes away. And we can help the family clean those up. That, again, this doesn't necessarily all have to do with Medicaid. It has to do with long-term care planning and working with our clients to see that these are the needs to be able to have that agent be able to do everything. Heidi, what do you do when you have a client who is a little hesitant about initialing these paragraphs because they're like, well, we're giving away the farm with giving that to somebody? Because I know we get that question from a lot of attorneys as well. When we tell our estate planning attorney friends who don't do elder law, we need these paragraphs for any long-term care planning with or without Medicaid.
So I do get that, and I understand it, because you're essentially signing away your life. You're signing so that your agent could literally sell your house from under you tomorrow, can literally go to the bank and take out your money in the middle of the night and skip town. Now, obviously, there's civil lawsuits for theft and the like, and exploitation that can be filed, but a lot of times that money's already gone by the time you figure that you find out that something's happened. So what I say to clients is that you need to be able to trust your agent completely. And if you have any kind of hesitancy, then you should not name that person to be your agent on power of attorney. If you're worried that they might relapse into drug addiction or alcoholism, then they maybe should not be named as agent. Or if you're worried that their spouse controls everything that they do, and you know their spouse and you don't see eye to eye on financial issues, then maybe you should not name that child as your agent, or whoever that person happens to be to you. You must be able to trust them. The other thing to think about is, even if you don't necessarily sign these powers, there are still ways that agents who are unscrupulous can try to get around them. And one of them would be to just take out all of the money from the account. If it's a bank account, maybe write a check for everything and take the money anyway, even though you've not signed the superpowers, is what I've seen happen. And I have seen elder exploitation and civil theft cases happen with power of attorney documents where the superpowers were not initialed. So it can still happen. My view and opinion, this is just my opinion, is if you don't trust that person completely, then don't name them.
Yeah, and there's.
What do you think, Amy?
Yeah, no, I'm the same way. I mean, all of us who do estate planning as well, you know, they usually pick the local kid or the oldest kid. Talk to your clients about that. Let's step away from that. Believe me, you know, if they're not chosen, most people aren't going to have hurt feelings. It can be a big job to be somebody's power of attorney and keep everything under control. I tell people, and it may not be that they're doing it on purpose. It may be more of a negligence thing. I tell them, if your kid can't balance their own checkbook or keep up with their own bills, please don't add them the additional burden to be doing yours as well. Pick somebody else, and there are professionals out there that will do this. So,
and another thing, and I forgot to add this, is that for gifting, you can put in some guardrails. You can say any gifts have to be consented to by X. And maybe that's another kid that you trust. Maybe that's an independent advisor, such as your CPA or your attorney. Or you can also put in a guardrail that says all gifting and asset transfers and eligible beneficiaries to when you create or change rights of survivorship have to be according to my already given estate plan.
yeah,
You know, it's not 100% foolproof, but it does help and give some guardrails.
yeah. And remember, there is under the guardianship statutes as well, that if you have a power of attorney, the agent who's gone rogue on you, there is statutory authority for you to get in there. If the person is related by spouse or child or grandchild, then you'll have to do the extra step of being able to file that petition to suspend the power of attorney. Otherwise, the power of attorney is not suspended automatically upon the filing of the incapacity and the guardianship. So make sure that you look at the guardianship statutes and explain to your clients how this works. The other thing is, you can, as another guardrail, as Heidi was talking about, put it that if somebody is acting as your agent, when they're acting, that they have to do accountings. And who those accountings have to be shared with. So that also helps with what they're up to and what they're doing, if you want them to do that. The next one then, if you go down the list in the statute, is to create and change a beneficiary designation. Yes, this is separate than the survivorship paragraph. These are two separate, and they have to be individually initialed or signed, because they are separate in the statute. You've got to pull that statute out and read it again if you haven't looked at it in a while, since the new law came. It's not new anymore. We can't call it the new power of attorney law. And if you see fellow colleagues that are still using the old power of attorney, gently tell them the law changed. You don't have to go, hey, by the way, it was 10 years ago, get up with the program here. But you're going to want to make sure, because it is hurting clients out there in the public if they're using the wrong things. The worst, though, is when the client comes in with one that came off of the internet and it says Florida at the top and has, you know, it's 2 pages. And as soon as you see it's 2 pages, you know it's not going to work because it doesn't have details in there, because general powers of attorney don't work anymore in Florida. That you have to tell them this doesn't work to do this. But it's so important. I believe this is probably one of the most important estate planning documents, especially if their will is going the way that intestate would go anyways. I mean, they should have a will, but this document, you're not getting any. If you don't have this, you're stuck for anybody of any age. We're firm believers. I know Heidi's firm is too, of even getting kids 18 and over to get these things signed as well. So you got to look at also changing and creating these beneficiary designations. These are on all those accounts, okay? This is that you want to make sure that when we went back to that example where Heidi was the incapacitated person and or disabled person, and her aunts left her money, and the aunt's agent came into my office, and we were able to set up a third-party special needs trust on behalf of Heidi for the aunt. Well, if there are bank accounts or even retirement accounts, because we made sure we put the new language in there for retirement accounts, that we need to get this to this third-party special needs trust, we got to use this power as well to be able to change that or add a beneficiary designation to Heidi's new third-party special needs trust. So these all kind of combine together. Maybe there is not a contingent beneficiary. When you're doing estate planning, ask your clients who the beneficiaries of these are, because a lot of times they're only to one kid and they'll split it. Sure. We've all seen that. And the outcomes of what happens with that. So make sure, ask them who the contingent beneficiaries are, because that's when we see people coming in for, again, long-term care planning, not necessarily Medicaid, but just long-term care planning. Mom or dad now is sick. We're acting as power of attorney. These are one of the things that we ask for them. Who are the beneficiaries of mom's stuff? Let's look at her will. Let's make sure everything is going the way it's supposed to be going. Especially if there is no beneficiaries on those. And
even joint accounts too.
Yeah, even the joint accounts.
I've had clients, or actually I had an aunt and uncle both die on the same day. Their joint bank accounts and their jointly owned house by tenancy by the Attireties, everything would had to go through probate.
Yeah, and unfortunately with COVID, we're seeing a lot of one spouse, then two spouse passing away. So it is important, so important for people. And I'm sure any of you doing estate planning, you're seeing, your phones are ringing because of the importance of estate planning. The other thing is, in Medicaid, we do get that freebie $2,500 burial account out there to park $2,500, but we have to have a beneficiary on that account or it goes to probate. And then it kind of defeated its purpose of having the $2,500 burial account. So the next one is going down that statute for another separate one is power to disclaim property and the power of appointment. Again, I would suggest to separate these out and have these. You may go, but my client's never going to have to worry about disclaiming or is never going to have to worry about powers of appointment. How do you know? I mean, if we've all done probates long enough or trust administrations, you always get to be that attorney who gets to call somebody who that long lost aunt or uncle did leave them money, and it may be under a power of appointment because they got that income stream. So you don't know. It is fun when we get to do that. And so, but you just don't know. And why do you want to have to go to a guardianship to be able to do this for the sole purpose of a power of appointment or disclaimer when all they had to do was initial these paragraphs? So, but it's so important with the disclaimer with the homestead. And Heidi, you want to talk about how you're using the homestead for under the 732-7025, the new easy, basically waiver of homestead?
Sure. So a couple of years ago, there was a change in, I believe, the probate code where it gave some safe language or safe harbor language that we could put in a deed so that a married couple could transfer their homestead into their trust and know that we weren't going to have any kind of accidental waiver of homestead and get into other problems. For example, I've had cases where even though there was a deed to the homestead, to the trust of the homestead, after one spouse died, the other one went to go sell, and the title company wanted some type of either a homestead order from the courts or something, because they were saying that the first deed just wasn't enough to waive the I guess you would call, or I look at it as the inheritance protections of homestead. Basically, you know, the provision that says that if your spouse dies, you have at least a 1/2 interest or more in the homestead. So there can be times though when we want to disclaim that. And one idea would be we want to go ahead and transfer the homestead to a trust so that after both spouses pass away, the homestead can go per the trust and we don't have to worry about probate. If we go to prepare the deed and for whatever reason one of the spouses is already sick or incapacitated and just can't sign the deed, then as long as the other spouse uses a power of attorney, or if there is a power of attorney that's not the other spouse, they sign the deed, that will be okay. But we have to make sure that the power of attorney that we're using has this particular disclaimer for homestead purposes for the spouse. Another time we can use a disclaimer or homestead waivers is sometimes we'll do it when we're doing Medicaid pre-planning or Medicaid crisis planning. We will transfer the homestead from both spouses to just the well spouse on the off chance that the well spouse accidentally dies before the sick spouse. That's another strategy. And then in that case, if the Medicaid spouse isn't capable of signing the deed anymore, well, then it would have to be signed using a power of attorney that had this disclaimer or homestead waiver in it.
So now you got to keep looking through the statutes. There is some restrictions that you have to look for. An agent who is not related to the principal may not use the superpowers to benefit themselves or anybody that they are obligated to support. That being said, even though the default then means that the agent, if the agent is a child or somehow related to the principal, which most of our agents are going to be, that they can do things to benefit themselves. We have all seen banks, underwriters for the title companies, life insurance, whatever, looking for self-dealing paragraphs in powers of attorney. And if they don't see it, they halt us. Then you got, in fact, when I was preparing for this, Heidi and I both belong to the Academy of Florida Elder Law Attorneys, and we have a very active listserv that everybody participates in. And I was looking in there for different questions in that to kind of put or examples in here. And somebody actually had one where the spouse was being halted because the spouse couldn't do a gifting because I can't remember who it was, who's an insurance company or bank, if it probably was one of the big banks, for self-dealing, even though they're in the process of now arguing the statute with the legal counsel for the bank. Put that self-dealing paragraph in there, because it just, even if they're related, make life easier for your agents and your principals, because things like this can just cost them more money in the long run, even though you're on the right side of the law. Really go back and look at your powers of attorney. Think about things that clients have had issues with, or talk to other. That's why we're going to be getting this group back together and having some open discussions, because these are things that we are seeing. And that's why things like our listserv are so important, because we'll see it and then makes us go back and say, you know what, let's make sure that we have it in ours. So again, even though you don't need to have that self-dealing paragraph in there for relatives who are the agent, put it in. It's going to make your life much easier. Well, Heidi, I'm going to throw remote notarization over to you because the RON is the new thing now in Florida.
Okay, so I'm sure a lot of you realize that about a year or so ago, we were now allowed to use remote online notarization or notarizing over Zoom, I guess, or the internet, I guess you could call it. And if you do that, the power of attorney document cannot be one that has the superpowers in it. So, because otherwise if they have the superpowers, it's just not going to work out. So if you have a power of attorney document that does have superpowers in them, then it needs to be signed the old-fashioned way, where everybody is, together, or in the, the sight line, in their presence, and two witnesses and a notary with pen and paper and all of that.
Yeah, so this is important for people who don't know that there is exceptions to remote notarization if you are looking at it. I know, a lot of attorneys who do real estate closings are probably loving it, and that's great. But as estate planners, we got to be very careful of using it because there are such limitations in it. So if that's something that you're considering, go pull that new statute out and look at it. I apologize, I didn't put the statute number in there, but if you Google it, you'll find it quick. So another thing is when Heidi was talking about the clients that are hesitant about superpowers, you may want to remind them what the statutory duties are for their agent. Again, this is not something that you have to put in your power of attorney, but you may want to put it in there because not only does it remind your client of what those statutory duties are, it's going to remind the agent that, you do have statutory duties, because who will go and pull up section 709-2114 to go look these up? Put them in right in your power of attorney. It's long enough as it is. What's another, few paragraphs? But it's going to help the client and the agent remind them that these are. One of the big ones is that the agent may only exercise authority consistent to preserve the principal's estate plan. That is huge to remind clients of. This goes back to if you need to go to court because your agent has gone rogue, then you're going to want to go. These are the duties where you can get them on those hearings to be able to suspend their power of attorney, is to look at these duties and how much have they, violated, especially that first one. Now, there are times, and I'm sure you have this too, Heidi, when we're doing long-term care planning, especially Medicaid planning, crisis Medicaid planning, that we may be moving money over to just one child for one reason or another. Either that child's the disabled child, or the child maybe we can do a personal service contract for that child. Our policy in this office is we want anybody who is a beneficiary of the estate plan be on board with what we're doing, so that they know that, why we're doing it, so that there is no surprises and everybody knows that things may have gotten shifted a little bit. It's still preserving the estate plan, but we may have to do some things to be able to get the principal qualified for Medicaid. Otherwise, there's not going to be anything for anybody at the end, especially a disabled child. So do you have anything more on the duties, Heidi, to remind people of?
I think that one thing I have seen after the fact is that a lot of agents don't keep good records. They don't keep good bank records, and I guess also records of their time and their actions. So That's one thing that I find a lot in my practice.
Yeah, and it's a good another thing that's why putting these in your power of attorney, you know, and maybe even a note that says later or to the agents that say when you have to act, don't forget these are your duties and highlight adequate records to them. So other things to consider here. So in the statute, you may not realize if you have co-agents, which can be a pain in the you know what to begin with, but if you do have co-agents, the statute defaults to that they can act independently unless the power of attorney expresses otherwise. So talk to your client about that and write it exactly the way the client wants it. If the client wants them to write independently or to act independently, even though that's the default, put it in the power of attorney, because they may be taking this to third parties who may not be realizing what Florida law states. If they want them to act everything together, then put it in there. Maybe they only want the superpowers where they have to have a co-agent with them. You can do that as well. Detail out, everybody is different. Yes, we all start with templates, but then you got to make sure you ask the right clients and listen to your clients and see what they really want. Again, we talked about the good practice about adding self-dealing into your power of attorney. Okay. The other thing is there is a fair hearing decision out there for anybody who does do Medicaid planning. Heidi and I can get it for you. We know the attorney Heather Samuels on the other coast who actually argued this case where her client did not have, or the Medicaid applicant did not have the initial paragraph for the trust, but she was able to get the pooled trust open under the joinder, under the contract provision, which does not need to be initialed because it was, you're actually joining the pooled trust, not establishing a pooled trust. So the other thing is let's say you don't have trusts initialed in the superpowers. For now, you can use the trust under the pooled trust with that contract provision in there for a qualified income trust. Now, beware if you are not really up to date with what's going on in our elder law world here in the state of Florida. The state of Florida, DCF, Department of Children and Families, is pushing back on the use of pool trust for somebody who is 65 years or older. It is currently in a, what would you call that, a suspended mode right now, Heidi, as the elder law section in the Florida Bar and the task force for the elder law section of the Florida Bar and the Academy of Florida Elder Law Attorneys is working to fight that to be able to keep pool trust open for everybody. So Heidi, do you have any update? I know you're head of the
unfortunately I don't.
Okay.
So the way it stands now is that there's an internal memo that was sent out from the policy office to the DCF caseworkers saying that if they come across an application where somebody is over 65 and has joined a pooled trust, it can still be used for right now. However, we do think that at some point DCF is going to push forwards because they already have a proposed rule amendment it would have been the Florida Administrative Code, where they would have said that you have to be under 65 to use a pooled trust, whether it was for assets or as using it as a qualified income trust. So just beware, we can do it today, but I'm not sure about tomorrow.
Yeah. And this is why it's so important. And this is with any area of law, but especially, you know, we're looking at from an elder law standpoint. If you are doing any form of elder law, be involved with either the elder law section and or the Academy of Florida Elder Law Attorneys, because when that hit back in, what was it, late March or April, it was one person had found out about it because one of their Medicaid cases got denied. And it went through very quickly where everybody found out through the listservs and through the groups that we belong to that, and then they were actually able to kind of round the troops of getting people to give stories and situations so that they can work with the task force to be able to, and then find test cases to take up through the courts to be able to do this. Because if you're not involved, laws can change, administrative codes can change, and you could be doing planning for your client that you don't even realize is not allowed. And that could come back on you, and you don't want to be hearing from grievance committees or from, well, the Florida Bar or from your malpractice carrier. So it is very important to stay up to date on all this. And then we're going to round out that this doesn't really have to do with superpowers, but it does have to do with so many people moving to the state of Florida right now, that as we all know, the influx of people coming in, and the question we all get is my out-of-state power of attorney valid in the state of Florida? Technically, yes. It is valid as long as it met Florida's requirements of 2 witnesses and a notary, or the requirement of the state where it came from. I'm also licensed in Ohio. They, for some reason, years ago, took away the need of having 2 witnesses and only need a notary up there. So that's great. It works in Ohio. It will work down here, but then anytime you're going to, and we've had to get these opinion letters, they're not cheap. Sometimes it's just cheaper to go and get the power of attorney updated. The other thing is we have seen some friends of ours who do real estate, and I'm sure we have some real estate attorneys on here who could speak to this, that some of the underwriters have pushed back on those as well, that there has not been 2 witnesses and a notary, and this can slow things down, either trying to get the opinion letter or trying to, trying to get the underwriters or third parties, whoever it is, to be able to deal with this power of attorney. So, as much as we want to tell clients, it's probably easier on everybody to just update those update those powers of attorney and update the old powers of attorney that are over 10 years old. So yeah, because it's 10 years now. Everybody's manuals at all the banks have changed, and all these, and the insurance companies, they're going to be looking for stuff. And if you're still sitting under that old statute, fine. But again, is it worth the cost of doing an updated power of attorney if the principal can, versus arguing that old power of attorney still works? I had to open up a guardianship on one of my Medicaid cases up in Sarasota, because the underwriter for the closing would not accept the old power of attorney. We knew we could have fought it, but to be honest, it was cheaper to do the power of attorney, to do the guardianship and get it to run through that than it was. And I had a great attorney in Sarasota who did the guardianship up there. But sometimes it's the least restrictive route to go than to fight with the third party on these things. So does anyone have any questions?
My only comment about out-of-state power of attorney documents is if you have snowbirds that, they're here half the year and somewhere else half the year, for some of them, because our power of attorney documents are so different from what they have in their home state, I will prepare a Florida power of attorney, and then I will say that it does not invalidate their, Ohio power of attorney, because you have to be careful, because sometimes when you update a power of attorney, it can invalidate the previous ones. But I will tell them, to have one set for Florida and one set for up north.
Yeah, John Lonergan just asked if we have a form. Yeah, Heidi and I can put together a form power of attorney, and we can get it out to anybody who wants that. Lauren, is the best way is for them to just ask you, and we'll flip it through you?
Yeah, if they want to either put in the chat box if they're looking for something, or shoot me an email, either way is fine.
Okay, great. Thanks, Lauren.
You're welcome.
Anybody have any questions? Anything? Well, I hope you all enjoy. Oh, wait a minute. Yes, you can get the presentation materials. Lauren has those as a PDF version of our slides. So we will make sure that we get those to you. Thank you. I hope everyone enjoyed. And thanks to my daughter for doing the super fun, you know, super, yeah, I guess they were supposed to be kind of like, I'm losing the word, you know, superpowers. Superheroes, thank you.
Yeah,
superhero, because if you guys saw what my slideshow looked like before she took it over, yeah, hers was much, she just took my words and had fun with it. So, so yeah, but we can, you know, if anybody has any questions, don't hesitate to reach out to Heidi or I. Heidi is with Osterhout and McKinney in Fort Myers, and I am by myself, Amy McGarry. I am in Cape Coral. You know, we are here to answer any questions. We just want to make sure as you guys are doing these powers of attorney on your end, if you don't do elder law, that you just make our life easier when those clients do come in, or if you do have anything or any questions on elder law, you know, please come and join us on these meetings, because we are going to be starting to get going. If anybody has any topics, please let us know and we'll get those going as well. Some of the forums in the future may be what's called an open forum that we do in the elder law section, called an unprogrammed type forum, where we just throw out topics and people just kind of are in an open group talking about something like this, like, why do you see this, or what do you do if your client you know, has an issue where it doesn't have the let's say this superpower done. And that's how we get to being able to solve some of these problems. So as we all know, you can't practice in a vacuum, so we're all here to help each other out. So, well, thank you all and enjoy the rest of your Wednesday.
Yep, thank you.